Okay, welcome everybody to another one of Vanguard Insurance Agency's educational event. Today we have Shelley Bloom, who is the Director of Legislative Awareness and Training at Emerson Reed and Company. Emerson Reed is a partner of ours for many years, and you may see some of our lovely compliance blasts that we send out on a regular basis. We get a lot of feedback and great commentary on that. So Shelley is one of the brains behind some of those compliance pieces that you see. And her job at Emerson Reed is to train folks like us and internally on the on legislative awareness and regulatory compliance. So basically, her job is to make us look good. And so we're really happy. She is a very busy woman. She has been the legislative chair of Pennsylvania Association of Health Underwriters in the past, and she is a wealth of knowledge when it comes to the PPACA and the ACA and ERISA, as well as many other things. So welcome, Shelley. Thank you for joining us today. And I think the first thing Shelley wants to cover today is something that we're getting a lot of questions on. A lot of this information that we are going to talk about today are items that we get regular commentary on and regular questions on. So the first topic of conversation is the OSHA Emergency Temporary Standard, which is the guidance on the mandatory COVID-19 vaccines, which just went into play. So Shelley, I'll turn it over to you. I will say, if anybody has any questions, we have a small group here today. Feel free to unmute yourself along the way. I guess we'll take breaks, Shelley, right? And we'll try to answer any questions that come up. And as I said, we have this being recorded, so we'll send it out after the presentation. So thanks again, Shelley.
Thank you very much, Ed. It's a pleasure to be here with all of you and to be able to help you to understand some of these crazy things that are going on, specifically related to OSHA. I know that we heard from the president back in September about the mandatory vaccine, and we waited for OSHA to actually write it. It was released on November 5th, and it will become effective for employers on December 5th. There is some information out there that says not till January, but January is the extension for whether or not you're going to do testing and how you will do testing. So this OSHA requirement is something that all employers that have 100 or more employees need to prepare for. And when this was announced by the president, there was a lot of conversation, well, how do you count your employees? So we have that information in this piece. So Ed, if you want to scroll down a little bit where it talks on the first page about covered employers. So it tells us how to talk and how to find that we've gotten to 100. And on to the next page at the top, we're talking about employees as those that are full-time, part-time, variable hours, seasonal, remote workers, any way that you have an employee, that is an employee that you need to count. So that is a good way just to say anybody that's there. And if you have if you are an employer with employees in different locations, in different states even, as long as they are your employees, you're still adding them together and you're counting them, much like you do with the ACA when you have control groups. So if you get to 100, even if you drop below 100, and this is all based on November 5th of the date. So November 5th is when it was published. November 5th is when you will count your employees. If you have 101 employees on November 5th, you will be subject to the OSHA mandate for the vaccine. If you drop below 100, you still need to comply. On the reverse side, if you start out with less than 100, but you move up to 100 at the time that you approach and get over that 100 mark, you will need to comply with the vaccine mandate. So that gives employers a little bit of an understanding of where am I today? If you're 100 on November 5th, then you need to comply for as long as this vaccine mandate applies. Now it is scheduled to be for 6 months. It is a temporary mandate. The emergency temporary, the ETS, emergency temporary standard is what it says. Now, we all know that something that is temporary can become permanent. It can be written into law. It can be changed. So we'll have to watch and see what happens with all of this. And that's probably a good time for me to talk about, first of all, where are we now with the law? Now that it has been issued into the National Register, we have a number of lawsuits. The particular lawsuit that I want to talk about just for a few minutes is with Louisiana. So Louisiana said that this is not something that is allowed to happen, and they are challenging it. So there is conversation about it. There is also talk that it may go to the Supreme Court very early in the new year. So we will continue to watch that. I also know of a number of lawsuits that other states are bringing, as well as private employer groups. I did read about one lawsuit today that is going to be issued very soon, and it's a challenge about whether or not OSHA really has the ability to write this kind of an ETS, an emergency temporary standard. It appears that they are not given this right by Congress. So there's a lot of challenges to this that you're going to see as we move forward. And as Ed said, we will continue to keep everyone updated. So Ed will get bulletins on those as there are major changes that he can share with you to keep all of you informed. I say all that to continue along with what you need to prepare for right now. December 5th is not very far away. There's a lot of things that the employers need to do. So you want to move ahead with this as though it is going to be the law and it is going to be what happens, just because there's such a short time frame. OSHA is also taking comment on this law for the first 30 days. So it was published November 5th. You have 30 days from November 5th to get any comments in. You like the law, you don't like the law, it's going to impact you in this way. If you have any examples, they would like to get examples. Understand that anything you send in will become a part of the published comments that they always make. So be careful if you are sending anything in. But as this law with many others is a challenge, they're already taking polls about the popularity of the law, about those who support it. And from the date that it was issued to now, there is a little bit of a waning interest in actually doing these vaccine mandates. So it's certainly a moving target, and we will just continue to watch what happens with it. Ed, if you can move on to the next page. So some of you probably, go ahead.
So I'm sorry, Shelley, I might take a second if you want to talk, because I think this page downloaded is only a single sheet.
Okay.
So, let me leave this up. I did have a question though. Well, two questions.
Sure.
Maybe that could be food for conversation. One, are there any classes of employees that can be excluded from the 100 employee calculation? And two, are there any, I think one of the things that we're hearing a lot of and questions on is, what type, other than vaccine, obviously that's a controversial topic, and some are still not confident in the vaccine and are having and pushing back on employers. My question is there any language, and maybe you'll cover this, that covers testing, or more importantly, antibody testing, and if there are antibody testing, if there are antibodies, does that help with that mandate from a perspective of an employee?
Yes, I can go over both of those for you. The first one that you asked was related to employees, and are there any types of employees that are excluded? So there really are not. An independent contractor is not an employee. An independent contractor is not counted towards your 100 employees. If you have a staffing agency, all of those people that you employ in the staffing agency are going to be counted toward those 100 employees. So basically, if they're on your payroll in any way, shape, or form, they are going to be counted as an employee. There is something that's a little bit of a twist on this, not about counting employees, but about what kinds of employees will be covered by this vaccine mandate. And this is probably what you may have heard of, Ed, or others have heard of. And it's if you are an employee and you are going to the office on a regular basis, or you report every Tuesday and Friday, or if you're going to the office in some kind of a regular time frame, you need to provide your employer with proof that you have the vaccine mandate. They'll be looking at that one date if you got the Johnson & Johnson, or the second date only if you got the Pfizer or the Moderna vaccine. You can get boosters, but this doesn't require you to get a booster. It only requires you to get what they call fully vaccinated. So it's the one J&J or the two from Pfizer or Moderna, and they're looking at that second date. You need to provide those to the employer. If you don't, then you will not be allowed back into the office. There is a testing opportunity, which I will get to in a minute. But if you are full-time working from home as a remote employee, you are not going into the office, then you are not going to be subject to the vaccine requirement. So I'm working from home today. I have been ever since the COVID started. As long as that's the permission of my employer for me to continue to stay working from home, I don't need to go to the office. I don't need to get the vaccine because I'm working from home. I'm never going to run into my coworkers that, the spread of COVID could potentially happen. The other class of people that are allowed to not get the vaccine would be those who are always working outdoors. So if you happen to be a forest ranger and your work is outdoors, and when you're writing your reports and things, you're at home, you're never working with your other employees. If you generally work from home, but you decide that you need to go in the office, or the employer requires you to go into the office, then you will need to get a test within 7 days if you're not vaccinated. And so there are 3 types of tests that are out there. There is the PCR test, which is the test that is done by the lab. There is the antigen test, and then there are the tests that you can get at the pharmacy. However, what the law says is that you are not allowed to self-administer and self-report your own test. So if I'm not vaccinated, I go to the pharmacy, I pick up a test. I have to have that test monitored. So someone will need to monitor that. It could be telehealth that would be helpful. It could be the employer in some way to see that I took the test and they're able to read the results before they let me in the office. So there are 3 different ways that you can get the testing done. It's up to the employer to write in their rules how they want to do the testing, how this is going to apply. And again, the actual testing part of it doesn't start until January 5th. But the vaccine mandates and the requirements of the employers to get all of this out is for December. So those are the exempt employees. There is talk about mask requirements. So mask requirements are required while you're in the office. There are some exemptions to that. If you are in a room alone by yourself, you have walls that go floor to ceiling, you have a door that closes, so you are completely away from everybody else that is in the office. You are then able to remove your mask. Otherwise, you will need to keep it on as you're moving about your office. The only other exception to this would be if you're having a meal or lunch or something together, you're able to temporarily remove that mask. You also need to keep the mask on while you're in the car. If you need to travel with another employee of the company, you both need to be masked while you're moving, and that's only if you are not fully vaccinated. So if you're vaccinated, you're okay, but if you're not vaccinated, you will need to comply with the mask mandates. So there is information that the employer is required to provide to the employees. So Ed, if you can scroll to the next page for us. Yep, we talked about the testing stuff. Keep going to the next page. So there we have employer support, and we're talking about information to provide to the employees. So it's this next section that we want to cover here. There are a number of things that you need to provide to the employee, and this is the stuff that you need to have ready before December 5th. Your employees need to understand, as an employer, what are you going to require of them, and this all needs to be put in writing. This is general information. You can make it more specific based on what you do as an employer, the types of employees you have, the environment in which they work. Do you have some working at home and some coming into the office? Do you require them to come in every week? So you see that you can adapt these things to what works for you, but you do need to get this information down and get it ready for your employees. So what are the requirements? What is an applicable exclusion? So you are allowed to have an exclusion for a health problem, as they call it here, a disability, or a sincerely held religious belief. And there is more information that's available from OSHA and others about both of these. There is some information in here that says, if I have a health reason that I'm not able to get the vaccine, my employer is able to review that and still determine whether or not that is a valid reason for them. So if the doctor that I got the exclusion from is from a different state from where I am, my employer may not accept that doctor's information, and hence I may not have a medical exclusion. So that's some of the information that you as an employer want to put down, what you want to see. There is additional information out there about religious beliefs, and there is some opportunity for an employer to question those, but a lot of that has been litigated more, so there are more clear pieces in ADA that you can take a look at and determine if you're treating your employees properly. There is determining their vaccination status. What do you need to look at? When they are off, how are you going to pay them? So this law says you have to allow them to take up to 4 hours off to go get vaccinated, both the first time and the second time if they're getting the Pfizer or Moderna shot, or just the 4 hours for the J&J. If they have a reaction to the shot, then you also need to be able to allow them to have time off. You could require them to use their PTO, their sick time, their vacation time, or you could choose just to pay that. But you need to have those rules and procedures all set down in writing about what you're going to do. On to the next page where it talks about your record keeping requirements. And these are equally as daunting for you as an employer because you need to keep track of who is fully vaccinated, who is partially vaccinated. So I got my first Moderna shot, but I didn't get my second one yet. Who is not vaccinated, but they have a religious accommodation? Do they have a disability? And if there's not, is there some other reason why? And you see they include in there in parens that someone is not going to get the vaccination, but they want to go through the weekly testing. So you need to have your weekly testing set up. And if you're doing that weekly testing, if an employee is testing every week to be able to come into the office environment, you need to keep track of all of those tests for every week that they are coming into the office. They're not vaccinated. You need to prove that you monitored the test, you have the test. And where do you keep all of these things? Well, they are medical records, so you do not keep them with the rest of the normal payroll records or personnel records. You should keep them at least in a medical file separate. You may want to have a separate file for some people that is specifically related to COVID. So you can see the documents that are considered okay, the different types of immunizations, and I think we've all seen these, so we're all pretty familiar with those and what the employer needs. But again, you need to publish these, you need to have these in writing so your employees understand what they need to provide. On to the next page, Ed. So on the next page, we are going to talk about what happens if an employee has a positive test, and what about the close contact. So we've seen some of the answers from OSHA before, but these are here very clearly. If you get a negative test, you can't be in the office environment anymore. You need to be sent home until you can come back. When you have a positive test is when you're going to be sent home. You can remain home until you get that negative test. Then you can potentially return to work. An employer is not allowed to tell the other employees, hey, Ed has his vaccine, he's safe. Shelley does not have her vaccine, she's not safe. You can't disclose vaccine status. If I'm the unvaccinated person and I do come to work with COVID and I'm sent home, the owner cannot say, look, Shelley was tested positive for COVID, and so we're sending her home. But you do need to have a way to tell everyone who is going to be, who may need to go out from a quarantine perspective. So if someone sits in the cube next to me and we have a lot of conversation, the employer will need to explain to that person that there may be a concern and they may want to get tested. So you'll have to figure out how you want to go through those types of things. But it is important, again, to know what you're going to do as an employer and have it in writing. There is an ugly penalty here. So the penalty for failure to comply is $13,653 per violation for 2021. It's unknown if that will go up for 2022. That amount was not disclosed, or that it would change. If an employer willfully violates or has repeated violations, then it can increase from 13,000 to 136,000. So it increases tenfold. Also, you need to know that there are some states that employers may have employees in that have their own state-based OSHA. There's a few of them out there. Arizona is one that I can think of, but there are some others. So they may have some separate state rules that are different. So Ed, if you can scroll down a little bit more to the employer action section, this is probably the most important part that we'll go over. And it's just a discussion again about the things that the employer needs to make sure that they're doing. So establishing that vaccine policy. And there is a link in that first bullet to the OSHA site, and it is a sample mandatory vaccine policy. So you don't have to create this completely on your own. OSHA gave you something that is a template, but remember, you can change this to be what's needed for your own employer organization. Along with that, you need to determine the vaccination status. You need to provide support for the employees to get their vaccinations. What happens when you have someone who tests positive, write down those rules. How do you assure everyone else in the workplace that everything is safe? What about false documentation? What do you need to do for that? And as employers, it's going to be hard to tell. So there may be some times when you might hear some kind of information around the floor. So you may want to discuss that further. And along with that, if a document is provided and it's false, what do you do then? I don't have any specific information from OSHA to talk about that, but I would assume that you would need to involve your own counsel. There's reporting requirements that you need to do for OSHA. So if you have someone that tests positive, I mean, definitely you as an employer need to know about that positive test. If you have someone that actually dies from COVID, then you need to report that to OSHA within a 24-hour period. So there's a number of things that you have to do, and time is very short to get this done, along with we don't know what's going to happen to the role. So I've done a lot of talking. Any additional questions from any of you on that?
Okay, I don't see anything in the chat. Anybody have any questions?
Okay. And I
So
will just say that continue to watch in the bulletins that Ed will send out in the future. Pay attention to, if you're a news watcher or a reader, what goes on, because this is going to be something that is going to change almost daily. The webinars that like we're doing today and others are doing over the course of this week may be out of date just as quickly as they're done with all the changes that happen.
So Shelley, I mean, one question I have is, those are some pretty severe penalties you mentioned for employers being non-compliant. How do you envision, or have they stated how they would enforce this?
There has not been a lot of conversation about that yet. I assume it will be some kind of reporting. It could be from employers, it could be from employees. It's just hard to tell, and depending on the violation. So I'm sure we will get some additional information about that. And yes, they are very severe penalties. There's also talk about taking this down under 100, but that hasn't gone anywhere yet, but it doesn't mean it won't in the very near future. So like I say, it's controversial to many, and there certainly are a lot of challenges. I've heard 23 states that are going to challenge it. We've only seen a few so far, and I've heard of over 1,000 employer lawsuits that are ready to be dropped. So I do think that it's going to make a quick route to the Supreme Court. There's already been 3 challenges related to vaccines at the Supreme Court, and all those times the vaccine mandates have been upheld. This is a little bit of a different thing. And there's also the challenge about whether OSHA actually has the congressional permission to do this. So you haven't seen the end of it yet by any stretch.
So more to come, certainly.
Definitely.
Okay, so should we move on to employer obligations under health and welfare?
Yes, yes.
Sure.
And while you're getting that up, I do want to just throw out one other thing that I saw that was very interesting in the news today related to vaccines. And this is about Moderna specifically. Moderna was given a lot of dollars to help to create the vaccine with 3 doctors from the National Institute of Health. And there has been an ongoing battle, I guess, for a year now about whether or not Moderna has sole rights to the patent for the vaccine. And they don't want to acknowledge that they received money from the NIH. They don't want to acknowledge that there were other doctors from NIH that were helpful in this. So it's just an interesting little thing that's bouncing along the side here as the president wants to help other smaller nations that can't afford the vaccines to get these. They're wanting to get those from Moderna. Moderna is not being completely cooperative from what I'm reading. So yet they've made quite a lot of money from the vaccines. It's said that by the end of the year, they will have made $35 billion from the vaccines, billion with the B. So it's a lot of money. But behind the scenes, there's just a lot of things going on, not just the vaccine mandate that we're looking at.
Yeah.
So now we have health and welfare plan reporting and disclosure obligations. So this is a checklist that is available that Ed can share with any of you. It goes through just generally the types of things that you as an employer need to be concerned about. Some of these don't apply to all sizes of employers, and I'll try to point those out quickly as we go through it. The first page here talks about employers that need to have an ERISA plan. So we're talking about an SPD, a summary plan description or a summary plan document that has a number that ERISA acknowledges. It has to be numbered. It starts with 501. It may go on to 502, 503. You can have your health plan document be 501, your life insurance 502, your dental 503, or you can put all of those together in a wrap plan document. So any employer that has 2 or more employees is required to have an SPD or a wrap document. I know that prior to the ACA, a lot of employers didn't worry about this. It wasn't investigated very much by ERISA, the Department of Labor. But ever since the ACA began, there has been a lot more scrutiny about employers and having your SPD or your WRAP document. It has also been much more publicized recently that employees are able to call up the Department of Labor and complain about something that their employer did, and that can be investigated. So that can be a way for an employer to have some kind of an audit start without really any knowledge of it. So SPDs are required, or a WRAP document. SMM is a summary of material modification. So this is an amendment to your plan. Once you get your plan written stating who is the plan sponsor, who is the plan fiduciary, who is eligible for the benefits, when do you have open enrollment, how can an employee term, what are qualifying events, what does an employee need to do. So you get the idea that it's all these things that need to be written down. You can include the information that you have from your health insurance carrier, such as the contract that lists all of the things that would be covered, or more likely list those exclusions to the plan. You can include those in your SPD, but it's important that you first of all have one, and that you share it with your employees and you update it in the form of that SMM, the Summary of Material Modification. You have 210 days after the end of the plan year in which you made a change to actually make that amendment. So they give you lots of time to do it. You can amend your document when your documents get too wieldy from a lot of amendments. You may want to just recreate or create a new document where you're incorporating all the amendments that you have, and then you redistribute that document. The document can be distributed in person. If you're distributing in person, you probably want to know by initials or check mark who received that document. You can send it online. You should include a specific link to the SPD or the document that you're going to send out. You can also post it on your intranet, or if you use a payroll service that has a dashboard that employees can go to, you can post it there, but that can't be the only method that you use to post that. Along with all of this, there is a Form 5500. The Form 5500 is only required for employers that have 100 or more participants in any one of their plans. So as I said, I have health is 501, my life is 502, my dental is 503. If I have 105 people in my life insurance plan in 2021, then I will need to do a Form 5500, a report to the federal government that is also available to all of us. We can go to freearisa.com and you can see anyone's filing of their Form 5500. Failure to do that filing in a timely fashion can mean a very large penalty. If I do not realize that I'm supposed to do that filing, and I realize it 2 years later when I start working with Ed and he gives me that notice that I should have and I didn't, I'm able to do the delinquent filer program, raise my hand and say, I didn't know I had to do this, so the fines are much smaller for that. So those Form 5500s are generally due the 7th month after your plan ends. So if you're a January renewal, you will need to get your Form 5500s in by July 31st. If you're not a January renewal, then you'll do yours accordingly. And with the Form 5500, usually there is an SAR, a Summary Annual Report. It's a couple paragraphs. It talks about what happened with the plan in the past year. So self-funded groups, if you're familiar with those, self-funded plans do these often, but it's a requirement to send that out after you file your Form 5500s. Any questions on any of that?
Yeah, just one comment I'd like to make. One thing that we see quite often with employers is two things. One, if you are not a large employer and you're not having to file a 5500, then a lot of times we often see that they don't think there's any need for a WRAP document or an SPD. And then on the other side, the other thing we hear is for small employers is that it's often confused with an SBC, summary of benefit coverage, or the actual documents that the insurance company provides. So I guess the question there for confirmation is that that does not make an employer compliant by having those documents that a carrier provides, correct?
You are correct about that, Ed. The SBC is the summary of benefits and coverage that came to us through the Affordable Care Act. It is required to be given to the employees every year. It's separate from your SPD. Also, some carriers do call what they give to you instead of a contract. They may call it an SPD, but it's really that contract between the employer and the insurer about what is going to be covered, what is not going to be covered. It does have eligibility and other things in there. That document from the carrier can become part and parcel to the SPD or the wrap document that the employer creates. But it needs to be that plan number 501. So that's one of the first things, is that when you see it and somebody says, I have an SPD, it's easy to tell that it's from the carrier. It won't have that plan number 501 or additional on the front page, but there are additional things in there. And I'm sure, Ed, that you have some favorites that you work with, some third-party administrators that you can provide to any of the people that are on the call today if they need that. There are administrators that this is their sole function, is to do this, and they do it very well. There are simple documents that can be downloaded and you can fill in the blanks and get them. And for small employers, maybe that's the easiest way to do it. As you get larger or you have more complicated classes of employees and different benefits that you offer to different classes, you really need to work with the third-party administrator with their attorneys that are in there that can get all of this down properly for you. And it's really hard to do this quickly. So you don't know oftentimes that you're going to get an audit until you get that audit letter, which is really scary. It's 6 pages of bullet points of information that you need to provide to them within 15 business days. So they don't give you very much time. You definitely can't usually create an SPD or a wrap document if you don't have one done. So you have to hire an attorney to get a stay to be able to provide this later. So it just becomes very complicated. You can find some of these simple documents for maybe as little as $500. You can pay thousands of dollars for them. So it really depends on what you need as an employer. But this is one of the things that I always talk about, and I know, Ed, you and I have talked about this different times, that yes, employers have handbooks, but the DOL doesn't look at your handbook as the official document. They only look at your SPD or your wrap document as official.
Yeah, this is so important, and I think there's so many misinterpretations of this regulation. One question I have, well, a few questions actually. One, there's, as you said, there are third-party administrators that will handle wrap documents, summary plan descriptions, and it seems that the cost of doing so is so minute compared to what the penalties could actually be. So I would suggest, and we talk about this all the time, I mean, it doesn't make sense not to do this in a lot of cases. The other question I would have is a little bit more complex. So what if an employer has several benefit plans that they're offering their employees, and they do have over 100 participants on one and are required to file a 5500? Are there any relaxed regulations or penalties towards an employer should they leave out one product, let's say, that was not on their 5500 when they had one that was, so let's say we have 7 different benefit options and 6 of them are on that 5500, and they said, oh, I forgot my AFLAC plans. Is the penalty still the same, or is there any relaxed interpretation of that?
So the penalty is still the same, and it starts at $110 per person per violation per day. So you can see how it does rack up. And if an employer is willfully violating this, the penalties can be higher than $110. Conversely, if the employer did their best and they filed that Form 5500 in good faith and just left off one of those, and what you happened to mention was AFLAC, which tends to be a voluntary program. So there's a question about, what really is voluntary, and that's one that can be debated with your TPA and also with the DOL if you ever get into that position. But the DOL, when they're doing these audits, has the ability to lessen or make greater the penalties that you have there. I will say that when you're doing the Form 5500, if you have a wrap document where you've taken all of the plans and all of your SPDs and you put them together, then when I hit my 100 plus on my life insurance, but I have my health and my dental and my vision all wrapped in that, I have to report on all 4 of those lines because they're in the wrap document. However, if I had my health separate from my vision, from my dental, from my life, and I go over 100 on my life, I only need to do the Form 5500 on the life section of it. So there's pluses and minuses to having a separate document for each, and that's why it's really helpful to work with a third-party administrator that's very experienced or your attorney that can do this. Do it yourself is not a very reliable method.
Yeah, that was going to be my last question for you is, should employers try to do this on their own? But I think you just answered that.
No. And I did see a question pop up there about how often audits happen, and the audits have been increasing year over year. You can see data from the Department of Labor that shows that every year they're employing more. When the ACA started, they hired a couple hundred auditors, and they have continued to hire more auditors. So know that when you get that letter, and if it gets to a point where you're going to get a visit from the Department of Labor, they're probably going to come with other agencies, IRS, ADA, others, and they will spend days, weeks, months. I was involved with one of my employer groups in an audit that lasted on and off for 5 years before it finally completed. So they ended up not having any penalties, but they spent a lot of money in attorney fees to get through that. So it's scary. You don't want to get the audits. You don't want to get the letter. And they are happening more often, and the penalties are larger than they've ever been. So it's easy to spend the $500, $1,000, get this done. You have to replace your document according to the Department of Labor, ERISA, roughly every 5 years. So to spend $500 to $1,000 for a basic document every 5 years is money well spent. And I think that's what Ed's trying to get to, right?
Yeah, and are you seeing random audits, Shelley, or are they more complaint driven?
Rarely. I can't remember the last time I heard of a random audit. They are usually complaint driven, or there's something that is obviously a standout when the Form 5500 is filed, or something else to bring the attention of DOL, IRS to this.
Okay.
I did see a couple other questions pop up here. Do these regulations apply to organizations who are offering contributions towards employees' health care via the health plan, as opposed to offering a specific health plan? So these regulations apply to all employers, whether or not you make contributions. You are required to tell your employees what you're offering, how do they enroll, how do they add or delete people. All of that needs to be in this SPD. So it's basically how you do what you do about everything. Yeah. So if ever you have questions on leave or anything like that, it's all what's in your SPD. So it all goes to that.
So just to add to that, Shelley, I think the question is specifically geared towards Health Pass, which is a private exchange in New York. So if the question is more about whether because you're with Health Pass, you as an employer don't have these responsibilities, the answer to that question would be no. You are, no matter if you're with a private exchange or you're with a health plan direct, you do still have these responsibilities. And correct me if I'm said anything wrong there, Shelley.
No, you're correct. If you're a part of a PEO, professional employer organization, a MIWA, any way that they're pulling employers together oftentimes the employer has a contract with the PEO or the MIWA. Here's what they will do. Here's what the employer is required to do. But ultimately, you're still the employer. It's still your responsibility. So if the PEO said, I'll create this SPD for you, and they didn't, they're not going to get the penalty. You will as the employer. So it's ultimately, it falls on you as the employer.
Great.
Good question. Thank you.
Yvonne?
So the next page, it talks about COBRA. So COBRA is a federal requirement when you have 20 or more employees. Counting COBRA employees, you count parts of employees to get to a whole one, which is different than how you count for Medicare secondary payer. And, you know, this is one of the weird things that comes up all the time. When you're counting for Medicare secondary payer to determine, am I an employer with 20 or more, and is Medicare primary or is Medicare secondary, you're counting every head, or belly buttons as we used to refer to them in the industry. Versus COBRA, you're counting parts of a person. So I might work 15 hours a week, Ed works 25. When you add us up, we're 40, so we're one person. But you don't do that with Medicare. With Medicare, Ed and I would each be a separate person. And so Medicare rules need to be explained to the employees. Hey, we're a group of 7. We are a group where Medicare would be primary for any of you who are eligible for Medicare, not just when you turn 65, but if you have some other disease or illness or condition that allows you to be on Medicare. COBRA requires employers, if you're 20 or more, you need to give them the initial notice or the initial general notice. That's often the part that I see that is missed most often, especially if an employer is doing this on their own. If you hire a third-party administrator to take care of your COBRA for you, it's a big relief for you for the small amount that you pay for having a third-party administrator, because they send out those initial notices. You tell them, hey, I hired Ed today. So they have a few days to get that information out to Ed to tell him all about COBRA and his rights to COBRA. If Ed then leaves me at some point in the future, I report that to the third-party administrator. They will get the COBRA notice out to Ed and any of his qualified beneficiaries, dependents that were on the plan. They will follow all the timeframes that are required. We just went through COBRA subsidy that was available over the 6-month period. So that was really good to have the TPAs to do all of that. So a lot of COBRA responsibility, a lot for the employer to take on with everything else that's been happening related to COBRA. A lot of third-party administrators also will indemnify you. So if they make a mistake, they will represent you in court. They will pay for claims up to a certain amount. So it's really good to look at that third-party administrator. The next section talks about notices that are required to go to an employee every year by the employer. So these are things like the CHIP notice, the Women's Health and Cancer Rights Act notice, the Newborns and Mothers notice. There's a notice of privacy rights that they get every year. There's special enrollment rights, so that tells them when you have a qualifying event, how much time do I have to get on the group plan, get off the group plan. So these are available if you work with a third-party administrator for your SPDs. A lot of times they will provide these notices to you, the employer, free of charge or a small annual fee to get these. I can give Ed some additional information about how to pull these up and to be able to provide those. The Medicare Part D notice is at the bottom here. This is the participant notice. So we just went through this where by October 15th, every employer needs to make sure that if they haven't provided the Medicare notice before, you need to do that. Best to provide to every employee, because you never know if there's a spouse or a child at home that might be eligible for Medicare. There's also a reporting of the employer to CMS relating to Medicare. So that's on the top of the next page, and that says that the employer is required within 60 days of their renewal date to go to the CMS website and to report about the plans that they offer, and are those plans creditable? Is the prescription part of it. Is it as good as Medicare? And then it asks things like, how many people do you think you have on Medicare? They're not asking you to ask your employees, but just generally what information you know. To my knowledge, there's not any penalty for failure to do that reporting to CMS, but it is a requirement. We do send out a reminder bulletin every year that Ed will send out to all of you. So it's just a good thing to do every year. The CHIP notice is one of the notices. The 51 plus is for the Mental Health Parity Act. They are focusing more at the federal level on all things related to mental health parity in the last couple years. So look for a lot more restrictions and things that need to be reported related to mental health parity as we go on. The next section is all about ACA. So there are grandfathered plans that may still be out there. If you had a plan that's been in place since March 23rd of 2010, you haven't made any changes, it is a grandfathered plan. So you need to let your employees know every year that they have that. If you're in a state that offers grandmothered plans, so New York does not do that, but New Jersey does. So you're allowed to have a plan when you're a small group that is not ACA compliant yet. If you have those, you need to let your employees know that you have a small group plan, it is not ACA compliant. Slowly, those are phasing out as well. The federal government still allows them, then the state has to allow them, then each carrier can decide if they want those or not. Within here, claims is things that your carrier takes care of often. Rescissions we don't need to worry about. The SBC we talked about every year. By the effective date, you have to distribute that SBC. The W-2 reporting. This is an important one that we will be updating soon. As far as the W-2 reporting for medical, yes, if you have 250 or more employees, then you must report the cost of the medical on your W-2. In box 12, DD is where you put this information, and you have some latitude about what you need to report there, but you must do that. Along with this, what I wanted to tell you is that we are fast approaching ACA reporting, so it's time for employers to do their 1095-C and 1094-C reporting. Starting January 1 of 2022, if you are an employer that sends 100 or more forms to the IRS, could be W-2s, could be 1095-C forms, it could be any other reporting forms that you have. If your total sending to the IRS is 100 or more, starting January 1 of 2022, you are required to report electronically to the IRS. So this is a change. It's a big change for 2022. Ed sent out a bulletin to you probably about 3 or 4 months ago about this. So if you need another copy of that, I'm sure Ed can provide that to you. But this does apply to, if you just look at your W-2s and 1095-Cs, if you're over 100, know that you need to do your filing electronically for all of your IRS reporting forms. So your 940s, your 941, everything else that you report to them all has to be electronically. And then a couple more years down the road, it's going to be any employer with 10 or more employees will have to report. So they want everything to come in electronically. Just a quick update on the 1095-Cs. The format hasn't changed this year. There are 2 additional codes that relate to ICHRA, Individual Coverage Health Reimbursement Arrangements. So only for employers that offer their employees an ICHRA, that will be a change. Otherwise, you're just completing lines 14, 15, and 16. The difference for the 1095-C is in the due date this year. So starting for the 2022 year, reporting on 2021, you must get the 1095-Cs to your employees by January 31st. Yeah, January 31st. It was always the date, but the IRS and ACA always gave us an extra month plus. So March 2nd was usually the deadline we had to get those out. That since we had to report back in 2015, But this is the first year they are saying, nope, we're not going to be as friendly anymore. So January 31st, same date that you're getting the W-2s out, you have to be delivering those 1095-C forms. The 1094-C is the same thing as it's always been. If you're filing by paper, you have to get it in by the end of February. And if you're filing electronically, you get it in by the end of March. Again, understanding that if you file 100 or more, that you need to have that electronic filing happening. The last piece on here, the FLSA and the notice of coverage options, this really relates to a form that the ACA came out with back in 2012 or 2013, I'm sorry. And it is a form that has been updated really just with a change in the date. Within 14 days of the date of hire of a new employee at your office, you are required to provide them with this form. And the form says, yes, as an employer, I do offer coverage, or no, as an employer, I do not offer coverage. Whichever one you answer, you still need to tell the employee that there is an exchange or a marketplace where they can go to get their insurance. So if you're offering, it gives you an opportunity to give a little bit of an overview, but they need to get this within 14 days of their date of hire. The employer does not have to give this out ever again. So a lot of employers still don't have those or don't show that they sent them out. It is important to get them out, and they should become a part of the new hire packet going forward. The next page on the top, we talked about the 6055 and 6056 reporting, which is the 1095s and the 1094s that need to go out. The next section is just general employment law, and a lot of the things that you see on here are items that would normally appear on the posters that you put in your offices for your employees. Also, the places where you get your posters from, they are now providing additional information so that you can electronically send this to your employees. Because I've been working from home since COVID started, it's important for people to know what is being offered here. So we have ADA, ADEA, the FMLA notice. If you are an employer with 50 or more employees, you are generally subject to Family Medical Leave Act. There is information on the poster about FMLA. It's important that the employer put that in their handbook, their SPD, their WRAP document, but it does appear on the notice, so it's one place for employees to get that, and you can get that electronic notice and be able to send it out. It also talks about USERRA, so if anyone is participating in the military in any way, that USERRA notice will be there, and as well should be in all of your other documents.
Shelley,
and then just quickly on to, yeah.
Can I just ask one question there? So just on that same topic that you mentioned before about the enforcement of pushing things electronically, has there been any push to make these mandatory available electronically? I know in the past it's always been, the question's always been, can I provide it electronically? Now is it more of a push to do so because of such a remote, because of the workforce becoming so much more remote than it was?
Especially during this COVID pandemic and the fact that we're still under the emergency rules, all of the agencies have been very forgiving about getting this information out, and such as providing SBCs. There's a bit of a forgiveness period to get it out, not by effective date, but shortly thereafter. The same with these notices. So the way I look at it is it's my responsibility to give my employees this, and if I have a way to do it, I want to get it to them. I'd rather be safe than sorry. I don't want to have to face a penalty down the road, and all of this stuff should be properly documented too. So if I am posting it, but there's no employees in my workplace right now, do I have an electronic copy? When did I share that with everybody? Is it posted somewhere else so they can all see it? So I want to make sure that I'm following the rules as best I can as an employer, and I'm documenting that. And if I were ever audited, I would be able to come back and do that. So yes, electronic copies of everything are being much, much more accepted with ACA and now with what's happening related to COVID.
Great. And
the last page, I really don't need to go through that much other than to say that you have other documents that are required, your cafeteria plan, so your Section 125 plan, your POP plan, additional things that you may want to provide. Record retention says that you should keep all of your documents for 8 years. So whether you scan it in and you keep it an electronic copy, you keep your paper copies, you need to keep all of that for 8 years.
Okay.
And Ed, I'll let it go at that. So any additional questions?
So does anyone have any questions, final questions for Shelley? Yeah, we will be sharing these documents. We've actually sent these out before. The health and welfare obligations is something we send out on a regular basis because it never gets old. So yeah, we'll make sure that we send that out, as well as we'll be posting and sharing out a copy of this presentation. So Shelley, can't thank you enough for doing this for us today. Really appreciate it. This was incredible information. I think it's information that every employer, as we all can see, it needs to know. So thanks again.
My pleasure, Ed. Thank you very much.
Yeah, and thanks everyone for joining us today. We'll see you real soon.
Bye-bye.